If I tell you the kind of jugaads which India and Indian stakeholders have adopted to weigh the subject of defections, you would actually start laughing, and it would be really comic were it not tragic. If I decide not to take part in the voting on the floor, how does that change the legality of the defection? So these are what I call reciprocal reverse paradigms of delay, which give you an idea of how the 10th schedule is distorted. Unfortunately, talking about the 10th schedule and defections forces me to use the old Shakespearean adage, the law is an ass. We, the operators of the 10th schedule, and that means all stakeholders, not politicians alone, but everybody, have actually made it an ass. If I tell you the kind of jugaads which India and Indian stakeholders have adopted to weigh the subject of defections, you would actually start laughing, and it would be really comic were it not tragic. It is actually deserving of tears, but you will laugh. As I said in a recent address, if Gayalal, the original chap in 1967, was alive today, he would not blush, he would not turn over in his grave. He would go and jump over a cliff for not having thought of any of these things as are happening today. With that preface, let me give you a few examples. And each will be interesting. It will shock your viewers and readers. It will interest them. It will amuse them. And it will tell you above all Indian jugaad, our great genius to render non-functional something created with the highest ideals, to render distorted something intended to be very noble and high. So the first is a fundamental question about reform in the speaker's post itself. You must know that we have adopted these things from Britain, but what happens in Britain? In the very old days, speakers were elected unopposed. An unopposed elected speaker gives a huge amount of force and power because you are unaffiliated genuinely. Later on, although in England you continue to be affiliated to a political party, you actually left all connection with that party and nobody opposed you. Now that's the first reform we have to bring. All this long sermonizing and very rhetorical sermonizing from the pulpit that when I sit on the speaker's chair, I leave all my affiliations, I am not political. That's just not true. An assembly speaker cannot at all sever his umbilical cord. He is a partisan person of a particular party, anybody, any party. So we need to start from the source, from the absolute threshold about the speaker's status. They must be now the speakers of assembly and of the parliament must be elected unopposed, must be given complete authority to be able to be independent. And without that reform, nothing will improve. Number two, why that number one is important is because the fulcrum of the 10th schedule is the speaker. He is what people call a persona designata. He is the only person who can decide 10th schedule. Suppose tomorrow the speaker is functioning but is unwell, if he is not attending, or I'll give a worse example, the speaker is resigned. Theoretically, one view is that nobody can touch the 10th schedule because he and he alone can do it. He is the chosen, named arbiter. Now, that is why my first point is important. The persona designata has to be brutally, genuinely, actually independent, not sermonizingly independent. Third point, the inbuilt delay arises from the politics of it. So let's take two reverse examples. I am party A, you defect from my party and join party B, and probably in all probability disqualify her. If the ruling party is party B and the speaker belongs to B, there are any number of cases, not one, where they will indefinitely, interminably, indecisively prolong it for not months, years. The assembly term is normally 5 years. So 4 of those 5 years you will eat up in adjournments. I have done cases of Tamil Nadu where the speaker doesn't decide for years. I go to the High Court. The High Court says we can't give a direction to the speaker. We go to the Supreme Court. The Supreme Court says yes, we can give a direction to the speaker. Let the speaker decide within so. Then the speaker seeks extensions. He finally decides 3 months before the end of the assembly. In Manipur, in his usual style, Justice Nariman met the issue head on. And although he is not entitled to, he gave a rough guideline period of 3 months and said that in case that is not done, then the accused person must cease to function as a minister, the person who is accused of defection. But unfortunately, that is completely observed in the breach because it is not statutory, it is not constitutional, it is only the expression of hope. So these are what I call reciprocal reverse paradigms of delay, which give you an idea of how the 10th schedule is distorted. My fourth example, it is a misconception that there is a 1/3, 2/3 split concept in the 10th schedule. As you remember, there was earlier a concept of a split of a kind. That was done away with. You are not immune even if you go with more than 2/3. You become immune only if 2/3 go with you and, I repeat, and merge with another political party. The second and is forgotten by everyone. Take for example the Maharashtra case Shinde. They are clearly defectors because there is no merger with any party, neither with BJP nor with Ajit Pawar. But that part of the explicit text of the 10th schedule is ignored. Why? Because there is delay in courts in India. So that's my fourth example. These are all reforms when you talk of 10th schedule. Fifth, the time you take in deciding whether you have voluntarily given up your seat is mostly a waste of time, because now there are enough judgments which say that myriad situations of a diverse character will constitute giving up voluntarily. If I am seen with you, accompanying you in the bus to the governor and standing with the governor with a list of people, that is also defection. If I write to you, if I support you, if I vote against you, these are absent from a voting. Absenteeism was also 10th schedule. Not voting, voting contrary, of course, is obvious. But these are each taken up as a de novo paradigm every time the case comes, and speakers pretend to spend days and months on it to delay matters, or in the converse case to over expedite it. The sixth point or the fifth point is the period of notice. Normally, assemblies have a provision providing for either 14-day notice or 7 days notice. This is done for good, positive reasons of natural justice, but it can be easily misused. Take, for example, a case where a budget session is going on, and I am a defector, I leave your party and directly vote in the budget session the next day. As you know, a money bill budget session vote, the government will fall. Suppose the government is equal, 10-10, and one chap defects, or the government is 9-11, one chap defects, it will fall. Now, what has happened is I have defected, the government has fallen, but I will then seek 7 days notice. I will continue to enjoy the fruits of my defection. I will continue to be MLA. So, courts have rightly, there are 3 or 4 judgments which say even 7 days is enough, 3 days is enough. But in the recent Himachal case, the speaker rightly, by the way, in Himachal I was the victim, but the 1 day's notice. What is the need of notice? Because in Rajya Sabha election, you have to show your vote. The vote is there. That means you have voted contrary to the party whip. That means you are defected. So he gave them 1 day's notice and disqualified them. The budget session was going on. Otherwise, the government would have fallen. And that's my fifth point. The fruits of defection would have been enjoyed by you without you being punished. It did not happen in Himachal because I had also advised them, and it was the right advice that the speaker followed. But the point is, this is all the funny part of 10th schedule which nobody can do without either reforming But even after reform, you will have to be good intention to operate it, because I'm going to come to my last point is going to be that you must abolish the 10th schedule completely. The sixth example is the most absurd example, which is now fortunately pending for consideration before a larger bench of the Supreme Court. 5 judges of the Supreme Court have a para somewhat loosely worded in a judgment called Nabam Rebia. The intention of those 5 judges was totally different. They said that if I defect, but at defection or before defection or during defection, I level some kind of a genuine allegation about the speaker, lack of faith, malafides, bias, then the speaker is disabled from deciding the complaint against defection till such time. The speaker will not decide. Now, this para is, of course, first of all, wrong and loosely worded. Second, look at the bizarre way it is misutilized. It's happening in Maharashtra. This is absurd. Actually, this happened in Maharashtra. All the defectors sat together and decided that we are defecting. They know that we will be disqualified immediately by the speaker, rightfully, because they are clearly going away to other cities, sitting with the other side, openly cohabiting with the BJP and Pawar groups, etc., etc. So, before leaving Bombay, they make a complaint against the speaker. Imagine before leaving. So, they plan the defection. After they have gone and voted or are ready to vote, the speaker takes up the disqualification petition. The objection is raised, you can't decide. Unfortunately, with great respect to the Supreme Court, an erroneous order was made, allowing the speaker not to decide. The speaker was disabled, and the fruits of defection succeeded. Now, Nabam Revia doesn't mean that I'm a potential intending immediate defector and I disable the person who's my judge. It is like saying that I disable the judge by making an allegation that judge must be stand still like stone and I will go and do the criminal act. Before going and doing the murder, I will say, judge, I make an allegation against you. You can't decide. It's a very silly thing. We argued this. The Supreme Court has referred it to a 5-judge bench. And I hope it happens very quickly, because this silly interpretation and application of Nabam Revia must be changed immediately. The 7th is another stratagem, another jugaad adopted in India, which our framers of the 10th schedule, Dayalal, never even dreamt of. This new stratagem you will find again in the Maharashtra cases, and I've done all these cases. I am defecting tomorrow. Today, one day before, I file a complaint in the Election Commission. The Election Commission complaint says, look, I, Abhishek Singhvi, am the real party. The party which I am defecting from is not the real party. Please give me the symbol and please decide my petition. Then I defect. Now consequences follow on the 10th schedule, whatever happens. But before the speaker decides the 10th schedule, because I am delaying the 10th schedule decision, because of either a friendly central government or a friendly EC, I get my EC complaint decided first. What does the EC complaint decide? It decides, Mr. Singhvi, you are the real party. The symbol is yours. And that is then used to say there can't be defection. Now, the Supreme Court in Sunil Prabhu has debunked this. Rightly so. But again, the point is, in the next case, it will first be decided. It won't happen immediately. Supreme Court has specifically said that the EC and the 10th schedule operate in different spheres. It is ridiculous to say that the EC operating under a non-statutory symbols order. Symbol order is not even statute. It is under the statute which the EC makes it. And the speaker operating under the 10th schedule. The EC will be able to render the 10th schedule speaker's proceeding infructuous. It is ridiculous, and the Supreme Court has rightly debunked it. But in our system of case-by-case approach, next time again this will be used. Whereas honest administration would mean that it will be stopped at the threshold. You cannot say, now I've got the party, now I've got the symbol. Then, and therefore, validate defection. 8th point is the retrospective part of defection. It's frequently forgotten. I defect today, you are the speaker. You delay, but you ultimately decide. Or you don't delay, I delay the decision making by filing application after application. And you take 1 year to decide. In that 1 year, the government falls, the defectors make the government. But when the decision comes 1 year later, it is found that you have defected. Now the law is very clear. 1 year later, when the decision of the speaker comes that you have defected, it relates back because the act of defection is 1 year earlier. That decision applies from the inception because the act of defection is crossing the floor today. The decision may come 1 year later, which means on the day the new government was formed, it was formed by the vote of defectors, which means that those votes have to be excluded, which means that the entire government has to go. This is exactly what happened in Sunil Prabhu. And till what I have now spoken, the Supreme Court held in our favor. This is the amazing part. The Supreme Court said, yes, there is defection. Yes, the government, the judgment on defection that they have defected must relate back. And therefore, it must be deemed that the voting on the floor test of that day was invalid because it had the vote of those who defected. But then, and that's my 9th point, the Supreme Court, with great respect to them, nullified that conclusion by further finding, which is erroneous in law. That finding is that you are not liable for a government change because though the judgment relates back, Uddhav Thackeray never took part in the voting on the floor test. But that is irrelevant. Whether Uddhav Thackeray took part or not is not relevant. You have to only exclude the votes cast of the bad people. If I decide not to take part in the voting on the floor, how does that change the illegality of the defection? How and why? Therefore, these are issues. Then take another example, 10th point. I defect, and this happens when the party to which I defect is in power. So suppose the BJP is in power and a congressman defects. That congressman is not disqualified because the speaker is considering his defection petition for 6 months. He is made a minister as a reward for defection. He does not have to be re-elected for 6 months. By 6 months, new chunav may be held. Or after 6 months, he may fight an election and be elected. But he has enjoyed. The reward for defection is full. This encourages defection. You have to prohibit such stratagems by saying you can't be a minister without actual election. Have a rule. Change the law. I can go on and on and on. I have given you 10, 12 examples. It was wrong that this kind of jugaad, distortion, manipulation, deceit, lack of bona fides, does it not make the law an ass? And then my final point, does it not make it necessary to completely scrap the 10th schedule? Have a simple rule. The moment I cross over to you, irrespective of 1/3, 2/3, 5/3, 6/3, irrespective of party A, party B, you just have to fight another election to come back. Make it simple. And your act of departure and your act of fighting, since it will take time, will not be counted in any vote if you have changed. Your vote will be kept in a sealed cover. And number 3, the reform is have an independent constitutional level commission to decide defections or change the appointment of speaker system completely. Otherwise, it's a sham. It is not worth it. And it makes a mockery of our system. Apart from, actually, it has much higher consequences because one man, one vote, free and fair elections, level playing field for elections are all part of basic structure. By this one man, one vote becoming 2 defections, 1 vote, you are actually affecting the basic structure of the Indian Constitution. You are affecting democracy itself. So it's time you completely overhaul the system with a surgical knife instead of giving sermons.